This is a classic torts essay, and if you organize it correctly, you can score very high. Hi future lawyers, Christmas time is here and I have a surprise for you. I am reviewing the California Bar July 2025 exam questions. And in this video, we are breaking down question number 2, which is all about torts. Welcome back to our Aureus Christmas special. If we haven't met yet, I'm Vinicius Costa, a foreign-trained lawyer who proudly passed California Bar on my first try. I founded Aureus Bar Prep to help you master the bar exam just like I did. Before today's breakdown, a quick reminder. Our holiday promo is live. You get 25% off all Aureus packages until the end of December 2025. Don't miss it. And here's today's question. We are jumping into question number 2, a classic torts essay with negligence, battery, and damages apportionment. If you can organize this correctly, you can absolutely score high in torts. As always, on exam day, you're gonna have that whiteboard next to you. Don't be shy, use it. So let's look at our question. We have a negligence and intentional torts crossover question here. Here are our players. Ollie, he owns a field and rent it out for a soccer game. The teams, the Pelicans and the Jaguars. Barry, the coach of the Pelicans. Kate, a Pelicans player known for being very aggressive. And Yvonne, the victim. Ollie owns a field and rents it to the Pelicans who are playing the Jaguars. The afternoon before the game, Ollie inspects the field for dangerous conditions and finds nothing. But he does not inspect again before the game. During the game, Barry, the Pelicans coach, gets frustrated with the Jaguars players and tells Kate, his player, to play more roughly, knowing she is very aggressive. As expected, Kate begins playing very aggressively and eventually knocks down Yvonne, a Jaguars player. When Yvonne falls, she breaks her arm and badly cuts her hand on broken glass on the field. The referee stops the match. While the match is stopped, Yvonne asks Kate, "Why are you being such a jerk?" And Kate responds by punching her. Yvonne pushes Kate back. Kate gets minor bruises and Yvonne suffers no further injury. So, we need to answer a few things. Can Yvonne sue Ollie, the landowner, and Barry, the coach? Can Yvonne sue Kate for battery? And can Kate sue Yvonne back? And finally, if Ollie and Barry are liable, who pays what? So, let's start with part 1, negligence against Ollie and Barry. Whenever you see a negligence call, especially on the bar exam, think about duty, breach, causation, damages, and defenses. And because this is a sports fact pattern, you also want to flag assumption of risk and potentially a high standard like recklessness for some actors. Start with Ollie, the field owner. Ollie owns the field and rents it out, so Yvonne is effectively an invitee, a business visitor. That means that Ollie owes her a duty of reasonable care to keep the premises reasonably safe from known dangers, including making reasonable inspections and either fixing or warning about any dangers that could pose some risk to the invitees, like broken glass. The key facts here are: he inspected the afternoon before, not again before the game, and there was broken glass on the field that caused Yvonne's cut hand when she fell. Your breach analysis is where you show sophistication. You should argue both sides. On Yvonne's side, you should say it's entirely foreseeable that waste, including pieces of glass, could end up on an open field between the afternoon and game time. A quick reinspection right before the game is a low-burden precaution, and failing to do so is unreasonable. On Ollie's side, on the other hand, you can argue that he did make an inspection, found nothing, and the glass may have been deposited afterward. So perhaps his conduct meets the standard of reasonable care. But then, close it by saying that a fact finder could still find breach because a single inspection the day before the game might not be enough given the foreseeable risk and the low cost of checking it again. Causation here is very straightforward. And when we say causation, remember the but-for test. But for Ollie's failure to discover and remove the glass, Yvonne would not have cut her hand when she fell. And that kind of harm is a classic foreseeable risk of leaving broken glass on a playing surface. So, if the jury finds breach, causation and damages follow naturally. Now, let's pivot to Barry, the coach. The question here is whether Barry can be liable in negligence or even recklessness for his instruction to Kate. As a coach, Barry owns a duty of reasonable care to players and foreseeable third parties. And the opponents on the field, like Yvonne, are clearly foreseeable victims of his coaching decisions. The facts you must lean on are: Barry knew Kate was very aggressive, he had already told her once to play more roughly in the past, and that time she started a fight with a player from the opposing team. Despite that history, he reacts to rough play by telling her again to play more roughly. This is where the sports overlay comes in. It is true that sports participants assume the inherent risk of the game, like lawful tackles, collisions, fouls, and the law sometimes limits liability to reckless, not merely negligent conduct in that context. Your job is to show that you see that limitation and still bring Barry within liability. You can argue that telling a non-hot-headed player with a track record of starting a fight to play more roughly is at least reckless disregard for the safety of the opposing players, and the facts confirm causation. After that instruction, Kate began playing very aggressively and ultimately knocked Yvonne down. This caused the broken arm and the fall that led to the hand injury. If you have time, before closing negligence, take a moment on assumption of risk. Yvonne, as a soccer player, certainly assumes risks inherent in the game, ordinary rough play and collisions. She does not, however, assume hidden glass on the field or a coach intentionally escalating aggression through a player with a known history of fighting. Primary assumption of risk doesn't extend that far. There is nothing in the facts to suggest that Yvonne herself was negligent. So, you can mention comparative negligence only to dismiss it very quick. Then, you should conclude that Yvonne has viable negligence claims against both Ollie and Barry, subject to some argument over Ollie's inspection and the exact level of culpability we assign here to Barry. And that's all for part 1. Now, let's move into part 2, the intentional torts, specifically battery. Here, you want to clearly separate 3 different contacts: Kate's tackle during the match, Kate's punch after the match stopped, and Yvonne's push in response. Remember that battery is an intentional act that causes harmful or offensive contact with another person. Intent can be purpose or knowledge to a substantial certainty. And even if the elements are met, we still ask about consent and privilege like self-defense. So, looking at our case pattern here, first we have Yvonne's claims against Kate for the knockdown. Kate, after being told to play more roughly, begins playing very aggressively and eventually knocks Yvonne down. This made Yvonne break her arm and the referee calls a fall. This is a perfect place to show that you understand implied consent in sports. By participating in a competitive soccer game, Yvonne impliedly consents to bodily contact that is within the rules of the game, including tackles and collisions that might be fouls. So, you can say, even though Kate was very aggressive and a foul was called, that contact probably falls within the scope of what players consent to by playing soccer. You may also try to add that Kate's tackle was so far beyond the norms of play that it exceeded consent. But remember to mention the general rule of sports. Then, and much more important for your score, the punch after the match was stopped. The facts here are very clear. The referee stops play. Yvonne uses only words, "Why are you being such a jerk?" And Kate responds by punching her. This is no longer contact inherent in the sport. Implied consent to ordinary soccer contact does not cover an intentional, angry punch after the whistle. The punch here is an intentional, harmful contact with no consent and no self-defense because Yvonne hasn't threatened her physically. So here, Yvonne has a very strong battery claim against Kate. Even though she suffered no additional physical injury from the punch, she can still recover nominal damages for the invasion of her bodily integrity and, depending on the parameters, potentially pursue punitive damages because the conduct is deliberate and malicious. Third, we have Kate's potential battery claim against Yvonne for the push. After Kate punches her, Yvonne pushes Kate back and Kate suffers minor bruises. Technically, that's an intentional act causing harmful or offensive contact. So, we do have the elements of a battery here. But Yvonne has a powerful defense, self-defense. She has just been punched, so it is reasonable to believe further harm may follow, and a single pushback to create distance is a proportionate and immediate response. So, you would say, prima facie battery is satisfied, but Yvonne's action is privileged as reasonable self-defense, and therefore, Kate's battery claim fails. Finally, we are ready for part 3, damages apportionment. The call is very specific. If Yvonne recovers only from Ollie and Barry negligence, how would her damages be apportioned between them? This is where you bring in joint and several liability and contribution. First, joint and several liability. When multiple negligent defendants each contribute to a single indivisible injury, here Yvonne's broken arm and hand injury, each one can be held liable for the entire amount of damages as to the plaintiff. Also, consider comparative fault between the defendants themselves. As between Ollie and Barry, a jury would assign percentages of fault based on their relative culpability and causal contribution. Ollie failed to adequately inspect and maintain the field, allowing glass to be present. Barry affirmatively escalated the level of roughness by instructing a player with a known history of fighting to play more roughly, leading directly to the collision that caused the fall. You can argue that Barry's conduct is more direct and more culpable, so a court might assign him a greater share of fault. For example, more than 50%, and Ollie a smaller share. But the precise numbers are less important here than the reasoning. And your answer by mentioning contribution. If one defendant pays more than his allocated share, he can seek contribution from the other to bring their payments back in line with the comparative system. So, to recap the structure, you should internalize your own answer. Part 1, negligence. Identify duty, breach, causation, and defenses for both Ollie and Barry, and weave in the sports context. Part 2, battery. Separate the tackle, the punch, and the push. Analyze consent and self-defense explicitly. Part 3, damages. Joint and several liability to Yvonne, plus comparative fault and contribution between Ollie and Barry. If you turn that structure into a one-page outline and then write a timed 60-minute answer, you will hit almost every scoring opportunity in this question. And if you want more structured visual breakdowns like this for negligence, intentional torts, and damages, check out our Aureus bar prep materials. We turn these kind of essays into flowcharts, diagrams, and practice sets designed specifically for busy professionals and foreign-trained lawyers. You can download a free sample at aureusbarprep.com or through the link in the description below. Thanks for watching, stay focused, and I'll see you in our next video.